Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'll be with you for the afternoon hours here, and we're listening to some of the defense's closing arguments in the Adrian Loya case out of Barnstable, Massachusetts. He's a Coast Guard member accused of shooting and killing another Coast Guard member. Depending on which side of the case you believe, he was either infatuated with his victim or was somehow otherwise so fixated on her that the defense claims he couldn't conform his conduct with the law. That's part of the defense in Massachusetts of not guilt by reason of mental disease or defect. So the jury is really going to have to weigh ultimately what this defendant's mental state is in order to try to get into into the correct decision in this case. Nicole DeBorde is joining us now on the Law News Network. She's a criminal defense attorney and former prosecutor in hurricane country, it turns out, Houston. You're on dry ground.
We're on sort of dry ground at the moment. It's drying out still, but it's drier. How about that?
Oh, well, that's good to hear, at least that things are moving in the correct direction. And by way of an aside, you told me that your courthouse was destroyed in the storm.
Our state courthouse in a city the size of Houston was destroyed. So right now they are holding court in makeshift courtrooms for emergency type matters only, but we have no state courthouse in Houston, Texas at the moment.
Wow. So you have a lot on your plate. So we appreciate you joining us today. Now, this Loya case out of Massachusetts is absolutely shocking from a factual standpoint, but it all is going to boil down into whether or not the jury can agree with the defense that this guy is suffering from such an extreme mental defect. You know, there's a lot of words in the jury instructions like he could not substantially conform to the law. That doesn't mean 100%, and it doesn't mean 50% either. It means, what, 75, 80, 85%? But they're trying to say that he was so far deluded by what was going on that he couldn't conform with the law. It's a pretty tough standard to hit.
It really is, and when you think about it, most of the things that we see in a criminal courtroom are behavior that is outside the norm of what most folks are used to. So, you know, that fits every crime. And so his lawyers have the challenging task of making a jury understand that his coloring outside the lines, if you will, was so extreme and caused by some defect in his brain, putting him way into the territory of mental illness as opposed to what we see in just every other case down at the courthouse.
Yeah, so do you think the defense hit the standard in this case, or if you were sitting on the jury, would you go ahead and convict?
You know, that's a tough call. I mean, it's a brutal crime. There's a lot of thinking and planning that's gone into it. Jurors are likely to be very, very upset by these facts. I think anybody who's heard them is likely to be upset by these facts, and oftentimes that fills in how the jurors make decisions. And so I don't know is the question. I mean, is the answer to that question. I don't really know that they have gone far enough to show that this is a mental defect to the degree that he should be not responsible for this crime.
Yeah, so when it comes to the way the prosecutor handled the case in Massachusetts, the prosecutor has to argue over the hurdle of mental disease or defect once the defendant raises that hurdle. It's the state's burden to not only prove the case beyond a reasonable doubt, but to also prove, in essence, that the defendant was criminally responsible, in other words, sane. That's a little bit different standard than some other jurisdictions have.
Right, and what the prosecutor spent a lot of time doing, which is to be expected, is going into the detail about the planning. You know, all of the little steps and all of the time that had to be taken to make this thing work was whether you call it logic in the normal sense of the word, was logical. In other words, steps were taken so that other steps could then be taken so that his goal could be accomplished. And the prosecution did a good job of explaining all of these details. And when someone is suffering from a mental defect, jurors oftentimes have a hard time separating the logic that is required in making a complex plan from the mental defect. And I think that may be a big hurdle for the defense.
I agree, and I think that the prosecutor did a decent job of trying to sum up why this defendant should be guilty, because I'm hedging on the guilt side here, but I don't know the makeup of the jury. I don't know if, for instance, there are people with a lot of experience with mental illness on the jury or people with no experience with it, because if there are people with no experience, they might kind of buy into this tactic of throwing 4 or 5 experts on the stand, letting them all disagree, and then letting the jury trying to figure it out.
Right, and that's helpful to the defense oftentimes when you can have a variety of different opinions and make the mental health issue more clear and help people understand exactly why you can still take steps in an order in a linear fashion toward a goal, but still not be sane under the law.
Yeah, the law is a different standard from a mental health standard, and we've been really clear to point that out here on LawNewz, because a lot of people look and say, well, from a lay perspective, how can you say not guilty by reason of insanity? Shouldn't that make someone guilty? And it's like, well, it's 2 different standards. They use the same words, but they really don't reference anything remotely similar. It's a question, as I've paraphrased it, and again, I always feel guilty when I try to paraphrase a statute because we know never to do it, but it ultimately is a question in the first prong of the analysis as to whether or not the defendant knows right from wrong, and in the second prong, it's whether or not he could actually do what the law says.
Right, whether or not he can follow it. And, when a crime is as ugly as this one, people are going to have a really hard time separating his ability to control himself from the fact that he didn't control himself. And that's always the hurdle in these cases when you have a really nasty crime.
So I was trying to make notes as we went here about reasons why the prosecutor was probably argued that the defendant could follow the law, and here's what I came up with, and you tell me if you like the list. He, first of all, on the first prong, gave evidence that he knew right from wrong because he said that he expected the police to show up and shoot him. Now, brushing aside the extremely rare cases where a cop goes berserk and shoots and injures or kills somebody without reason, okay, I know it happens, but generally speaking, I suspect that you would agree with me that 99.99999% of police officers only shoot when they have their own lives in danger, and they know the difference. So saying that, rational people would look and say, well, the police aren't going to show up and shoot me unless I'm doing something wrong, so therefore he knew right from wrong.
Right. I mean, I think that's a super strong argument for the prosecution. And, the reality is that if you look at a crime like this, rational, right-thinking people don't commit crimes like this, is what a lot of jurors are going to think. And so that makes this argument still a challenge for the prosecution. I think it's a very strong argument. But, we're way past that once you have a crime where all of this planning went into harming someone and killing someone in this way. So I think it's a big step in the right direction, but they've still got hurdles.
I agree. The jury's got to really sort through a lot here, and with this conflicting expert testimony. Another issue that I thought would come up on closing arguments, and indeed it did from what I understand, was that he reported the initial issue in Alaska to the authorities. Well, that's an indication that if he's got a problem with somebody else who's in the service with him and he tried to go through channels, that he can understand the law and conform his behavior to it, at least in that situation.
Exactly. And, the fact that he has understood the rules enough to actually apply them in other circumstances is certainly evidence on the prosecution's side of this equation.
As far as conforming his behavior to the law, he had such a detailed list of things he needed to do for himself to carry out this twisted scheme that he had, that it's like, well, gee, he can certainly make plans and follow through with them, perhaps to a morbid degree of exaction, but he can do it.
Right. And that's the other thing. That's the details. All the little steps that took time in the planning of this go on the prosecution's side of the equation yet again, because, this takes rational thought. If I do X, then Y will occur. And, understanding the law and being able to follow it works oftentimes in much the same way. Now, the experts in this trial obviously had varying opinions about exactly how someone applies this type of logic and whether they can follow all the rules. But certainly he could follow some rules of logic, and that's going to be the prosecution's biggest toehold.
Yeah, no, another point that one of us came up with yesterday, and I forget exactly who it was. It was not my thought, and I can't remember who here came up with it, so I apologize to that person. But, one thing the defendant did is blamed his father for the death of a dog that was important in his life, but he didn't kill his dad. So there's a sense that, well, he was upset but didn't fly off the handle in that situation, so why did he in this other situation?
Sure, and oftentimes this sort of sudden passion argument, if you could be so blinded by a tragedy or an emotional circumstance in your life, you can have sort of this almost what the law regards as a temporary insanity, but it's not something this is not the way that they were trying to apply it in this case. In this case, they're saying this is a long-term, ongoing organic defect which causes him not to be able to comply with the rules. And certainly the fact that he has this incident, which created a lot of emotion in the past, was able to follow the rules despite the fact that he was very upset, again, bodes well for the prosecution.
Let me ask another question here before we dip into a clip of some of the prosecution's closing argument. There's this whole issue of the 4 experts up on the stand, and I started making this chart yesterday about the various diagnoses and, is this diagnosis correct? Is the other one correct? What's going on with these things? And ultimately, I heard some testimony this morning from one of the experts who was back on the stand saying something along the lines of, well, it doesn't matter exactly what the diagnosis is. You can agree with all these diagnoses and it somehow would absolve him of criminal responsibility, or there was some kind of convoluted argument like that. But if the state has the burden to prove that he was criminally responsible, or in other words, sane, does this mix of experts just really cut into the whole bearing of the burden by the state?
It's supposed to. Whether or not the jurors are able to sort through all that information and actually make a decision about what each of these experts had to say is the question. And they may discount some of it, they may discount all of it, and if they believe just one of the experts who believed that his defect was such that he could not formulate rational thought and prevent himself from committing this crime, then the defense wins. But emotion plays a role for the decision making of the jurors as well. And again, and I know I keep saying the same thing, but it's a terrible, terrible, long thought out crime. And I think a lot of jurors are going to have a real hard time with detailed expert testimony in order to absolve this individual of guilt.
So we listened to some of the defense's closing argument there, and the defense was really reading parts of this defendant's hatred of the victim into the record, and I was surprised at their ability to sort of use that in their favor and saying, look at the level of hatred. He talks about hating the victim. He talks about this assassination mission. He called the document Loya Wars, and the defense went there and said, that proves the mental disease or defect. It certainly doesn't put the defendant in a good light.
No, it doesn't. I mean, and I think what the defense is counting on in this circumstance is that, this just sounds crazy. No rational person would say and do these things for these reasons. And they wanted the jurors to be able to hear just how far out of whack their client was. And it could be effective. We'll certainly find out.
Yeah, let's listen to some of the prosecutor's closing arguments now for a bit. We'll be back to you in a second, Nicole.
Great, thanks.
And what's your most competent tool to do this? It's your common sense. You don't leave your common sense at the door when you come in to sit as a juror. Now, the defendant is certainly presumed to be innocent, but only until he's proved guilty beyond a reasonable doubt, which I suggest, again, we've done in this case. The Commonwealth has the burden of proving to you beyond a reasonable doubt that Adrian Loya murdered Lisa Trebnikova, shot Anna Trebnikova, and Jeremy McDonald, and all the other crimes that he's charged. And there are a number of other crimes that he's charged. But I have a limited amount of time, and I'm going to focus mostly on what I would...
We're going to break out of that quickly because the judge is back on the bench. Everybody sort of converged in the courtroom very quickly. It looks like they're talking about some of the charges, so we want to go straight to court in Barnes.